Welcome everybody to today's Saturday Connect and Collaborate. Raymond, we're so excited to see you. I saw Margaret, by the way, yesterday at a WITI event. So she said she was going to try to make it, but she sent her best.
Thank you.
So much happening now and I think probably confusion with just AI, what you can use, what you can't use when it comes to protecting IP as you're building, if you're vibe coding, if you're using agents. I mean, I have a slew of questions, but I'd love for you to maybe just start with just sharing a little bit about you. I mean, I know there's a wide variety of countries and music that you've done along the way. Would you mind just sharing a brief overview?
Right. I'm an IP strategist. I've had the privilege of working in multiple countries. I've worked in Japan, in Luxembourg, Estonia. I'm in Ireland now again. And you can guess from my accent that I am Irish. So I'm back at home. Uh, I've also had the privilege and pleasure of working with some of the smartest people in the world and being exposed to things that, uh, because I'm so fascinated by these, that I've learned a lot from what's happened in different industries. And because I was open to this, I was exposed to a lot more than people would often be exposed to. And what is interesting is that some of the things that are commonplace in some industries are unheard of in other industries, but can be very useful to apply as well. So that's something that I'm able to bring when I'm working with clients as well. I'm an IP strategist, and these days I work with the leaders of high growth technology and life science companies. That's typically companies that are venture funded. They've already had some funding, but they have ambition to become unicorn status. So that's generally my background. I think most people here know me as an IP guide, and I'm very happy to support what you're doing in WITI, David, as well, and the WITI community.
Thank you. Yeah, thanks, Raymond. And then when you think about, so one question I had just doing all my research leading up, was there something, whether either when you're in the music industry or technology, maybe one of your clients just did something you hadn't even thought of, right? Or just does anything come to mind like that where it's like, oh yeah, maybe obvious or not?
Yeah, it's sometimes people will contact me and say that, for example, the life of a patent is 20 years. And they may have something that's been going for 17 years, and there's only 3 years left on this. And they ask me, well, what can we do to extend the life of it? And I'm saying, okay, there's very little you can do. That, the 20 years is the 20 years. There's a few tricks that you can do. Maybe you can get a little bit more out of it. But then I ask them things like, when you were first doing this, did you give it a name? Because if you've given it a name and you've been able to build up some kind of brand value around this name, perhaps you can protect this with a trademark and you can continue extending out the life of this intellectual property afterwards. For example, the Nestle had the Nespresso capsules, and by the time they brought that to market, their technology was already 17 years old. So most of what they've done has been based on the trademarks of Nespresso, and also they managed to lock in people like George Clooney to be able to support this. And that's a massive intangible value as well. Just the contracts they have with George Clooney as the face of Nespresso and the stories they can build around that.
Wow. Right. So just naming it kind of puts a stake in the ground for you. And is that, I mean, but if somebody created something similar, but would that tie it into the underlying tech?
Well, it means that, if you've given this a name, a trademark, you can register the trademark. And as long as you continue to pay the registration fees, which, the renewals come up perhaps every 10 years, and you continue to use the trademark, you can roll this over. So, for example, Coca-Cola, the Coca-Cola trademark is more than 100 years old. So it's not like a patent. If they had patented their formula, they would have had to publish it for the world to see, and it would have expired 20 years after they first published it. So, but they are able to still continue to have the trade secret of the Coca-Cola recipe, all of the aura around that, but also the trademark of Coca-Cola has continued to survive now. And it's not just Coca-Cola, anybody who's got a trademark can continue, as long as they continue keeping it in use, they can roll this out indefinitely.
Right, got it. And I know Martin said at the beginning, I think you said once you put in the provisional, you have a year. I know that if you went in and made changes throughout, I think the year restarts. Is that kind of a strategy you would use to continue to maybe give yourself a larger window if you may have some holdups?
Yeah,
Or they,
the provisional patent application, and I hope I'm not getting too much into the weeds on it, but if you're doing a patent application, one of the options that you have in the USA is to file a provision patent application. And when you do that, you have up to 12 months. Now, it isn't that it's about a year. Once the 12 months come, sometime before that, you have to convert that application into a full patent application. And if you do that, what happens is that the provisional application goes into the patent office, they put a stamp on it, and you now have a date of where the provisional patent application protection begins. But you cannot enforce the patent until it's granted. And as a matter of fact, with the provisional application, they put the stamp on it and they put it into a file and they don't open it, they don't examine it unless you convert this into a full patent application within the 12 months. Now, I did hear Carolyn mentioning the publication of this. It's published not after 12 months, it's published 18 months after your original application. So you have up to 18 months and you could withdraw your patent application anytime in that 18 months and it would still continue to be a secret. Now, if you don't withdraw it, and even if the patent doesn't get granted afterwards, the whole world gets to know about this. So it is one of the strategies that if you think that this is something that mightn't make its way totally through to grant, you might withdraw your application before the 18 months. You're right as well, David, that inventors, they don't just invent something and walk away. Like someone like Martin is continuously developing improvements. But if you have the underlying technology protected, your protection is backdated to that date as soon as you get the patent granted. And any of the improvements, it's just to the extent that they are different, that those things, the timeline will start from the time that you lodge the improvements.
okay.
Does that make sense to everybody?
I see heads nodding. Great. I think since the last time we may have gone a little deeper around this in maybe middle of 2025, right? Right. So we talked about AI. I think it was a little unclear for me. Can you write the patent using AI if you had the product that you didn't use AI? Like are there kind of
Well,
specific guardrails now
well,
on what
maybe if I can take maybe 2 or 3 minutes just to bring it back to basics as well, just to
yeah.
make sure everybody's on the same line, because we've been talking about patents and trademarks and trade secrets and things, and people could get a bit kind of confused as to what those different things are. So
Okay.
if I can give you what I call the ABCs of patents, trademarks, and copyrights. If you look at patents, what do patents cover? Patents cover typically inventions, processes. Like if you remember Chitty Chitty Bang Bang, Caractacus Potts was always in his lab developing things. Those are inventions and things that you could possibly protect by patent. So I talk about things or apparatus or articles. So A for apparatus or article for the patents. For the trademarks, we mentioned about, giving something a name. So something like Nespresso, Coca-Cola, even the shape of the Coca-Cola bottle is something which is identifiable as being Coca-Cola. And that's all around the branding. So A for articles, B for brand is your trademarks. And then C, when we come to copyright, copyright was for creative acts. So, for example, if you have music or books or photographs or paintings, all of those things are protectable by copyright if it's an act of original creativity. And that became extended to things like software and more recently content. So A, B, C for content very often can be protectable by copyright. So you can enforce that. And the copyright doesn't need to be registered, that from the time that you create this and you put it in some kind of tangible form, like you can't have a song in your head. You have to record it into a recording, you can put it on a DVD, or you can write down the notes on paper. But once you commit it in some tangible form, the copyright starts from that time. With trademarks, as we said, trademarks can be registered, or you can have a common law trademark in that you just start using it and you claim a right to using the trademark. So that common law right of trademark can be in place even without you filing a trademark application. Now, I should say that if you want to enforce it in the courts, you would have to go and prove that it was your trademark, and that could if you start getting into contention with somebody over a trademark, it could cost you 50 to $100,000 to really assert your rights in court. Whereas to file a trademark application is somewhere between kind of $500 and $1,000. So if you are strongly believing that this name is a good name to have, it is worth investing in talking to a trademark attorney and filing your trademark application. So that's your A, B, C of patents, trademarks, and copyright. So articles, brand, and content are the typical things that people here would be interested in.
Very helpful. And as you're creating your company, right, might be pre-funding, may not have a lot of funds to put in it right away. Are there right? And we talked about trade secrets, which we will get a little bit more into later. Are there just best practices people should be doing to prove that they kept it confidential?
Yes, so that's you're kind of saying something that for people who've been previously on a WITI call, we did talk a lot about trade secrets. And ABC of the patents, trademarks, and copyright, the fourth thing that is very relevant to a lot of people here is trade secrets. Because a trade secret is confidential information. And it's not just confidential information. For example, if my home telephone number, which is private telephone number, gets out, it's inconvenient for me, it's annoying for me, but it's not something that I suffer financial loss or somebody else doesn't get a financial benefit. So it's not valuable because it's secret. So that's not a trade secret. But for example, your customer list, some of the ideas that Martin has about his know-how for some of the things that he's doing, those are confidential information that is valuable. You could suffer a financial loss if those things leaked out. Or somebody else could leapfrog a lot of the work that you have done in building your business so far, and they don't even need to go to that expense. So they get a financial benefit from doing that. So you have confidential information, value that is confidential by the fact that it's confidential, and also that you've taken reasonable measures to protect the secrecy of that confidential information. So that's the thing that you were talking about, David, is that you do need to do things which are common sense activities to protect the secrecy of your trade secret. And if you can do that, that is something that the courts will back you up and protect you if somebody does try to misappropriate your trade secret.
I mean, and does all that stuff need to be documented, what you do, right? Like what I've done. It's easy to
Yes.
say I was very careful. So then board
Well,
meetings,
and
like
that's the thing. Yes, when you go to court, that you need to be able to show that, yes, this was a trade secret. This was my company's trade secret. And it is one of the difficulties that you have sometimes is that most trade secrets leave when an employee leaves the company.
right.
And because these days that trade secrets are digital and that it's not like somebody needs to even take a whole filing cabinet with them. These days, if somebody walks out with a USB, they could have a whole lot of your digital secrets on that walking out the door of the company. So you
Right.
need to be very aware of what are the trade secrets that your company has. This person who has just left, what ones were they in connection, in contact with, and were they able to take them and where are they going with this? What's the possibility? Because if you don't do that within the first 24 hours, you could be in a lot of trouble with that. So
Okay.
that's the first thing is knowing your trade secrets and being aware of that. Then when you do go to the court, you need to be able to demonstrate these are my trade secrets, our company protected these. These are the things that we did to protect them. So you have to satisfy the judge and you need to bring evidence on that. So you're right that it's much easier to prepare that evidence in anticipation of this than to try and prepare the evidence when you're in the panic of losing the trade secrets. Great to see
Love
Paulina coming up here with a question. So please,
it.
Paulina, go ahead.
Yeah, I had a question that I wanted to build up a little bit what just David say. What would be your sort of recommendation on maybe culture? Because what I've seen in M&A transactions that when I'm looking at the company to invest in, they have the employees and then they have the employment contracts. When we do the due diligence, we see that there may be don't have a good protection in terms of keeping the intellectual property within a company, rather, as you said, that when the person leaves, they might take it away. But then if we are trying to enforce them to say, hey, we will invest you if you change your employment contract, that is a sort of a cultural issue, because they say, hey, we started as a small startup company or family business. If we start changing the contracts, etc., just people will leave. We will lose the sort of the brain. How would you suggest to address this?
That's a very interesting question. Yes, you're correct that one of the disciplines that you need to have is that if you have those really, if you have the good contracts, first of all, where it does talk about, people's obligations of confidentiality and trade secrets and protecting the company's IP, you should also have a program of exit interviews that as the person leaves the company, that you need to remind them that, yes, you're no longer coming here. Your employment will be terminated as of now, but there are certain obligations that will continue after the termination. So you need to remind them of their obligations, because sometimes the people forget that they have the obligations after they leave. And if you can document you're doing that, that is also something that would be very useful for you to be able to show to the courts that you were taking all the best steps to protect the trade secrets of the company. This issue about contracts is really interesting, because very often I see this with companies as well. You mentioned about startups. Startups evolve and they get better and better at doing this as they go along. So you have the first employees and it's just the Wild West and it's a handshake and pals, people came together to do this. And then they take on somebody and they promote that person to a manager. And then as they take on more people, they keep changing the employment contract. So the latest employment contracts for the newest employees often are very good. But when you go back and you look at, well, what were the contracts for the founders? Those are the ones that don't have those protections in there. And those are probably the ones that have the most serious trade secrets, because the founders are the people who had all the ideas in the first place to make the company. And they very often feel insulted that you say to them that, hey, we need to go back and change these contracts. And it really is around the culture of the company. You're saying that, okay, yes, I know you started as a startup, but now you've built something valuable. And the value is based on what was in the heads of the people. And also, you're going to benefit from this value. If we're talking about a merger, that, the people who were the founders, especially people who have shares in this company, it's in their interest to make sure that this is all cleaned up. So often you do need to talk to them before they come into the merger to say that these are things that are going to be looked at. We're going to need to clean this thing up, or it'll impact the value on exit. It may mean having some very hard discussions, but very often the founders, it's in their interest to make sure that they've increased the value of the company as well.
Cool.
Does that answer your question, Paulina?
Yeah, no, yeah, thank you.
And like in the data, like when you're creating a data room for an investor, Raymond, are those the types of things they're looking for, or is that helpful to do it, or does it just depend on the stage where you are?
It definitely is something that is important. Now, one of the things that I find in-house lawyers think that just creating the data room is enough. And when it comes to the due diligence, because that's a big thing for investors these days, is that they are coming and they're asking different questions. Because the company is more than 90% intangible in value, they want to first of all figure out, well, what is this value? Do you actually own this value? Like sometimes these companies have been started up and they've done things, they've external developers, there's joint development, and they may not own all of the IP. They may not have the right contracts with their own employees about, saying that, work that you've done, you're working 8 hours a day and the other 16 hours of the day, things that you're doing in the evening time, are those property of the company? Are they not property of the company? You need to be very clear about this. Sorry, Phyllis, you have a question?
Yeah. You mentioned durations, that patents expire at 25 years and trademarks, you just keep funding them and they stay valid. But really, if say you're creating a website of your own creation that seems to be in the realm of copywriting, is there a duration for copyright, and is that specific to countries? Each have their own regulations, I assume.
With patents, it tends to be 20 years, unless you're in the pharmaceutical industry, and with the longer development cycles, they have ways of adding another 5 years to it. But typically, it's 20 years for patents. Good question about copyright. Copyright used to be originally only 14 years. But in the world of IP, copyright has done very well, I think. And it's been extended, and now, yeah, and it's different in different countries, but typically the rule is 70 years after the death of the creator.
Oh,
So
okay.
that's quite a long time. And if it's, for example, a movie, it's interesting because who's the creator of a movie? You could have the director, you could have the screenwriter, you could have the person who composed the music. And what it is there is it's 70 years after the death of the last of one of those. So it's quite a length of time. If it's an anonymous creator who you don't know if the person is still alive or not, they say in that case, it's 120 years after the original creation, unless there's some kind of evidence to show that we know who the creator was, and if we have information about when that they passed. Which is, so copyright is a wonderful thing for families of creators, because even after they pass away, that the families, this can be passed on as an asset to the family, that they'll continue to receive the benefits of something, something like, Agatha Christie, that her family would, 60 years after her death, still have the copyright.
Thank you.
Great, thanks,
You're welcome.
Raymond. And before we go to Dan, I had a question, Raymond. If you're going into some type of deal, maybe you're using, maybe use pieces of somebody else, of a partner's technology to build what you're building. Is it like an unlimited license you'd get to use it, right? Or like what's acceptable, right? Or if I build on top of like OpenAI or a particular model, are there things we should be looking for there? Or
Well, the first thing is when you're building on top of OpenAI, the first thing you should be looking is your agreement with OpenAI. And you'll
right?
find that that's been written by lawyers who tend to be a lot smarter than anybody else who's using it. And nearly all the rights go over to them. So you need to be careful about spending too much on that. If you're talking about using external developers, you need to be very clear as to who owns the IP rights on this. And it's quite
Right.
common that the external developers, like, don't forget, the external developers, if they're developing software for you, software comes under copyright. And copyright is in the original creator of the thing. So the developers could say, we're the original creators. So you need to be very careful in your contract to make sure that it's very clear they're doing something as, work for hire for you, for example, and that you own all of the rights. Something that I often talk to people about is that they might have a joint venture and one party brings IP, one party brings IP, and then they talk about, well, what do we do about things that we do jointly developing? And joint ownership of joint developed things is a nightmare. And that is very often the biggest difficulty that you will see at the end of these relationships. And, I know it's terrible to kind of talk like a lawyer, that you're going into the marriage and you're already thinking of the divorce. But I straight away, I get red lights flashing and warning people, for God's sake, don't have anything which is regarded as joint development or joint ownership. Have very clear understanding about who owns what part of it. And anything that you have as joint sounds very nice when you're going into the relationship, but it can be a disaster afterwards.
Sure.
Dan, I'm quaking in my boots because I know you're going to have a great question for me.
Yeah, I want to go back to the data room. So one of my concerns in the data room is I almost want to treat it like a skiff. Like you can come in and see stuff, but you can't download it. You can't take it out in your underwear. You can't do that stuff. So my concern around the patents, I've identified 10 categories. And within that, I've identified numbers of patents and I've scored them safe, cautious, forget about it. I did a very deep dive into all of the wearables. So I know what I'm proposing is not out there at all. So if I let someone in who's an investor, and guess what? They also have some expertise in the sport world. My concern now is, do I want to show them that? Or do you set up a data room in sectors? Like without an LOI, you can see this. with a formal LOI, you get to see this last part in between. So how do you view a data room? And B, should I even more than say I've got the patents until I've got a real LOI that looks like it's going somewhere, I wouldn't expose it.
There's a lot of things to unpack there, but let me, for the benefit of everybody here, let me say some things. One thing is, if you have a patent, and if it's a granted patent, that's something that anybody in the world can see anyway. So there's no secrecy around a granted patent. You do have patent applications. So a patent application which is less than 18 months old is still a trade secret of yours. So that's something that you want to be able to keep secret. But a granted patent is something that the whole world can see anyway. So I'm not as nervous about that. What I'm more nervous about is trade secrets and how you package them. Because if you put the trade secrets in a data room, even the way that you assemble them is digitally putting things together in a convenient way that even if some of your internal people wanted to do you harm, you've now assembled them in a way that they can just take them and run with them as data. So that's something you need to be careful of. And you're correct that you don't just assemble a single data room and whether somebody is under a confidentiality agreement or not a confidentiality agreement, that they can all come in and see it. You still need to decide what level. You can have different levels of this person is under confidentiality obligations, this person is not. You can show them different data rooms.
Okay, yeah, thanks. So for me, all the patents are identified. I don't have provisional patenting yet or any of that. It's just the strategic intent that's already ready to go upon funding. Then we can do all of that.
Okay, so they're more kind of invention disclosures rather than patents. They haven't been converted into a patent application and they haven't gone to grant. So, okay, so those are invention disclosures, which are very much trade secrets of yours.
Okay, thanks.
The other thing, if I can just caution everybody as well, is that be very careful as well of ranking that, oh, we think this is a great patent. Oh, we think this is a weak patent. Because sometimes that information can be discoverable in litigation afterwards. And the comments that you have yourself on your own patents or on other people's patents can be used against you in litigation afterwards. You just need to be careful as well as to having opinions on, oh yeah, this is a great patent or this is a shaky patent. I see Jared has a question.
Thanks, Raymond. Go for it, Jared.
I do, and I apologize for not having my video on, but my app keeps shutting down, so I'm trying to keep the bandwidth low. But my question is with regards to what you just mentioned a few moments ago. If someone's writing a stage show and instead of using music that they would have to then pay large royalties on, they wanted to use IP or AI to create music, like in Sona and whatnot. What you said about ChatGPT's lawyers making sure that they own all the rights to things, how does that work if say you're creating a stage show and you're like, well, I want to create country music or rock music, but I want to create it and then use it because Sona says if you pay the professional license, you can use it. Can someone then go out and use it? How is everything you're talking about related to things like that for like that stage show, say it becomes Cirque du Soleil at some point. So it's really popular, music's really popular. Now 10 years down the line, 5 years down the line, now is Sona going to come back and say, no, buddy, we own part of that? Does that make sense?
It does make sense. There's a few things. First of all, if you're talking about that you're not creating the music yourself and you're using something like Sona to create the music, that don't forget that that has been trained up on other data as well.
Mhm.
And you need to be careful that you're not infringing on the copyright of the original person who created this music. If they were able to track back to be able to connect what you're using to what they created in the first place. Unless you have some kind of indemnification from the AI provider saying that everything we're providing you is clean and that you don't have any obligations. But you'll find that unless you're paying them a lot of money, it's unlikely they're going to indemnify you against being sued by the original training data that was used in this. That's one part of it. So if AI is simplifying, you have training data, you have the model, and then you've got the output. And Sona owns the model, and they're not going to let you have that. The output, there is a question as to who owns that. And under IP law in general, copyright, it goes back to, I'm not sure if people have heard the story of the monkey selfie, but there was a journalist who went to Indonesia and took photographs of macaques. They weren't even monkeys, but everybody calls them monkeys now, in Indonesia. And the monkeys, he set up the cameras, he befriended these primates, and he set up the cameras so that they'd push the button and they could take pictures of themselves. And he published these in newspapers, got paid a few £100 for this in England. And then the photographs started appearing on Wikipedia. And he sued Wikipedia, and Wikipedia said, well, you didn't take the photograph, the monkeys took the photographs. And this went through years of court cases. But basically what it said was that because the monkeys took the photographs, and copyright can only be to humans, that he wouldn't be able to protect that. So the result of that is that anything which is not created by a human may not necessarily be protectable by copyright. And AI comes into this now as well. So this is created by AI,
So
and
if
they'd
you
say that
have
you're not the creator.
if you have input in terms of, because I do a lot of music with like vocally, and I create instrumental things vocally, and then I'm waiting for an AI program that can translate that to instrumental and things. So I'm creating part of it, but I'm using these programs to do it. Does that make sense?
It makes sense. And the thing that I'll say to you is that for as long as you're a small little creator and you're not making money on this, which is nearly every creator in the world, it's not a problem. But if you suddenly make millions on this and Cirque du Soleil says they want to come in and buy this,
Mm-hmm.
suddenly you get a whole lot of people coming out and saying that, oh, well, I had a part in creating this. Oh, you don't own this. Cirque du Soleil's lawyers are all over you as well. So it becomes messy. And sometimes even Cirque du Soleil will say that we'll buy it from you, but you just need to change the music on it. You know, there's things like this. So what I say is that IP law changes very slowly. I was saying this to Jerry in a breakout room as well. AI is changing every week. There's something new coming out. And it's just impossible for the law to keep up with it. And a lot of people are really trying to crowbar old laws from 50 years ago, 60 years ago into technology which wasn't around a week ago. And whether it's appropriate or not, which means that you're going to have lawyers on both sides arguing this. And the thing that I always say is that there are so many gray areas in this that these kinds of questions are going to make the lawyers very rich in arguing both sides of this. And I always say that the lawyers are going to be able to send their kids to schools, posh schools, for the next few years on the backs of the uncertainty around this. So I've huge sympathy for the creatives that there isn't a nice, clear, black and white answer to your question. But it is something that it'll only become a problem when you're madly successful and people are trying to fight for who has the shares of the spoils.
Got it. Thank you so much.
You're welcome.
Thanks, Raymond. Thanks, Jared. Anybody else? Questions, comments? Joel, you're up.
Just one thing about just added to the firstly, thanks again for doing this, and nice chatting with you before. You said about making music. Jared was talking about making music, and you said that if you made it in Suno, they own the data, right? They own the model, right? And the other person owns the data. But what about if the music that is created, the way that Suno works and Udio and all these platforms work is that they're taking data from 100 years of other people's music, right? So does that ever come into play when if you're in this instance?
Yes, and like as we said already, if this is an anonymous composer, if the music is more than 120 years old, you're okay.
Right.
But the good music is going to be the music that has got, Taylor Swift in it, it's got Nicki Minaj in it, it's got the Rolling Stones in it. And a lot of people are creating something that they want to sound like the Rolling Stones. And it may have, the model have maybe been fed by the Rolling Stones. And the Rolling Stones have deep legal pockets to come after people if they feel that they've been ripped off and if it's been a direct rip-off. Now, what happens is a lot of these tools modify it enough that you can't be sure there was the Rolling Stones. But as Niven said, there's software coming out as well, which is being able to backtrack to see what things were stolen from the original artists. And the artists are, if they can assert their rights, that's going to be a problem for you.
But inevitably, just to add one thing, inevitably, because we're using 100 years of other people's music, right? And just
Yes.
say I go on to, say I want to make a jazz record, okay, right? And I want it to be a certain genre of jazz or with certain instruments and da-da-da. They're going to grab that. They're going to be able to grab that. So if is what Niven said is like, are they going to be able to backtrack? Not that I'm trying to cheat anybody, but like I just mean, are they going to be able to trace all that? And so where does the copyright? Where are the lines for copyright or trademark infringement in these instances?
Well, as I said, you're going to have lawyers on both sides who are going to be arguing. And again, the lawyer is going to be made very rich. And I hope that the creative people, that there's going to be something left over for the creative people to make something out of it as well. It's not settled. It's not black and white. And that is something which can be deeply uncomfortable.
Thank you.
You're welcome.
Thank you. Okay, and so Raymond, when they tell you some of these AI companies, oh, buy the professional version, and then then you get a license. I mean, is that how much weight is that, right? Because if they built on top of something else, then who are they to say it's legal or not? That's not gospel, right?
Yeah, and like you do have, certain AI companies are licensing in material as well for training data. So, maybe that they do have, and they're only using clean data which they can stand over. But when you say it's licensed, the question is, what does that mean exactly? And you need to really look at the small print and see, are you indemnified against anybody? Because you're going to get not just the people who have genuine cases, but you're going to get frivolous people as well, who are just going to try their chances, especially if there's a big prize at the end of it.
Okay, got it. Carolyn, go for it.
Well, I'm stuck on the macaques.
Okay.
And I'm wondering how much you could protect with a process patent. The process of setting up something so that the monkey can take or something can take a picture of it so that nobody else could use that technique. So you'd be the only person producing those pictures.
I agree with you that, there are artists who, they throw a can of paint on a canvas and they make something, and it isn't like they tracked exactly where each of those spots was going to go, but they were the person who selected which kind of paints, they selected how they were going to swing this, and they had a general artistic concept of how it would generally turn out, and they get protection for that. And I'm with you that the photographer, he went to this place, he tracked down these animals, he built a relationship with them, he placed the camera in such a way that they would actually be curious about the camera, and he had an expectation that he would get some kind of an effect from that. Part of his own problem, though, I think there was bad lawyering involved. And again, maybe we're okay, this is something that we're being recorded here. But one thing is that when he was originally selling the pictures to the newspapers, he made up the story that the animals stole his camera, ran away with the camera, and took selfies with it, which added to the mystique of the photos that he was trying to sell.
Oh.
And then was used as an argument against him after, saying, "Oh, well, this is just the animals, you didn't set this up." But I think that if he had given the argument to say that he had put the equipment in such a way that he was expecting some kind of artistic serendipity, he could have maybe had a better case for the copyright of it.
Nice.
Good.
Thank you.
I feel
Thank you.
better.
Okay, Greg, or is it Margot?
Yeah, I'm seeing Margot's radiant
Margot's
smile there.
face.
Greg's name.
Oh, okay. I guess it's me.
Hey, Greg.
Sure, we can do the camera. Hi, David. Hi, Raymond. How are you today?
Hello, Greg. Good to hear from you.
So this is a real example. We invented something called the AI assurance stack. U.S. security agency is going to give us a certification for that. There's a whole bunch of IP built around that. And we're worried about Europeans, for example, using our term and our certificate to basically provide protections that they're not qualified to do in Europe. So we have DHS certification. We'll have 3 of them, U.S. Department of Homeland Security. We have, yeah, you're right. My daughter's telling me I should disclose. But a European company, notified body, for example, might use that and imply our certifications apply to Europe. They can only apply through us. What litigation options do we have in Europe?
Okay. Again, I know I should start all these things off with a disclaimer to say that I'm not providing any legal advice because I don't know the details of this. But what I can say is that I know that you already have some trademarks around the naming of this, Greg. I think you've said this before. Yes. So the trademark protection means that if you have the protection in those European countries as well, they won't be able to call what they're doing by the same name. Now, they could end up calling it by a different name, but with some kind of implication. And then you need to think is, are they doing passing off? Are they trying to, confuse the consumer? So those are the kinds of questions that you might be able to raise on that. The other thing is that the DHS, if I just finish with one last thing, the DHS approvals that you have are really an excellent barrier in the USA to stop people getting access to a lucrative market in the USA, which is wonderful. DSS certification in Europe has got no, the DHS certification has no interest to people in Europe, but at the same time, holding out to Europeans that they are carrying out what you're doing. That is something that I think that you would have a case to be able to make against them.
Okay. There's a lot of granularity to that. But anyway, thank you very much, Raymond. Great response.
You're very welcome. And, we can talk offline because I know Margot is absolutely right that, we shouldn't go into too much detail on something which is public, but you've asked some very good general questions and I've given a general answer to the general questions.
Thank you, sir.
Thanks, Greg. Thanks, Margot. Okay. Anyone else? Questions, comments? I had one, Raymond, just about writing the patent, right? Could we, using AI, I think I heard a negative comment from you last week, or just maybe there's just like similar, I don't know, words, too many M dashes or something. What, can you do that, right? I think sometimes that's a great use of AI to research and use AI to write a lot of it. Is that looked at? Do they frown upon that? Should you try to make it not look like AI? Any thoughts?
If you're using AI as a writing assistant, like that's, you can use AI to clarify your thoughts. What you need to be careful is not to be in a situation where AI could be considered to be the inventor.
Right.
So you need to steer clear a little bit of that. But at the same time, if you're the person who's coming up with the ideas and you're just using AI to clarify your thoughts and maybe interrogate some of the things that you're thinking about, I think you're still okay there. As things move on, the patent office is becoming more used to the concepts of AI being used, and they see things coming in. But there are some things as well which are kind of clearly invented by AI, and the patent office is saying there's no human involved even here, and so they're cutting those ones out. Noah.
Okay, Noah, go for it.
Yeah, it's actually a question for both of you, and then maybe Raymond, you can chime in. So David, in Stone AI, and when you guys are creating original content, for example, are you using the same level of military grade tracking of the prompts that you might use for your assistant that Raymond just brought up when it comes to writing screenplays or any sort of scripts for the content that you may want to either produce without AI or actually physically produce? Like, do you guys think that from the writing side, forget about music, forget about graphics, forget about video generation, but just for the actual text, if that level of tracking is necessary for your protection of ownership, for copyright, for trademark, for anything you'd want to legally file.
I think, yeah, it is. We haven't done too many scripts yet, but I think we would go through all the standard. I think you should mail it to yourself, right? And then register it with the Writers Guild. So we'd probably, make sure those are secure. And then as we create content, and we are doing some of you may have seen our I Am Alien show. That isn't really scripted, it's more unscripted. But selling that, and I'm not 100% sure, but I'll be checking it with Raymond so he can help guide us.
Yeah.
What do you think, Raymond?
Yeah, great question, Noah. When you talk about prompts, there's two parts to it. One is that there's some kind of delicate know-how there, and it could be that your prompts are a trade secret. And the other thing as well is you could think about the creativity of what's going into the prompts could also be considered copyright. The thing that you need to be careful about is when you feed the prompts into the machine, they become inputs to the machine as well. So you need to think about are you handing over ownership or making things visible, which you thought were your trade secrets, but now they become part of the machine. And that was something which was a problem in the early days of ChatGPT, is that people were putting in confidential company information into ChatGPT, and that confidential information became part of the training model for ChatGPT as well. So the company started shutting those things down very quickly.
So what's the solution when we're using these LLMs beyond paying for a license?
Turn off training, right? Turn off training. Turn off training. Does that mean does that protect you enough, right? I don't know. To Sam Altman, is that turn off trading, no problem. It's in the back door instead of the public one. Or can you count on that?
David, couldn't you go on use a Tor browser and then log in, or not log in, but just use it so it's not tracking you because you're not logged in? Use a VPN and a Tor browser. Is that an option? And you can take what you get from those sessions and then edit it yourself a little bit and then go into your logged in session. So now you have like 100 hours of work already done when you go into your logged in session. So they're not learning from it because you did everything from a Tor browser. Does that make sense?
Yeah, but I think you'd have to be very careful. But what do you think, Raymond? Right?
VPN might mask who this is coming from, but you could still be handing over your know-how. Just you're handing it over anonymously, but you're still giving the know-how to the machine as well. So there are things that you need to think about. And even when you talk about the paid version, you do need to still check very carefully the terms of what's the difference between the paid and unpaid. Paid doesn't necessarily mean that they're still not stealing it from you. And I use the word stealing very emotively, but just between friends here.
Right. Great. Anyone else?
Yeah, just one thing, David. With CyberBear, do they have a is it enterprise only, or could a writer say, hey, I'm about to write a screenplay and I want to use all the LLMs possible and I want to copyright it, register it, own it, and be the chain of title owner of this? Is CyberBear something that could be affordable for someone like a screenwriter?
I would have to defer to our founder and CEO. I don't know if she's there she is.
Hey, David. Sorry, guys, I'm under the weather, so I will not be on camera because I look like I was hit by a bus. But absolutely, was that you, Noah?
That was me.
Yeah.
Nice to see you, Pam. Nice to hear from you.
You too. Good to see you again. It's been a while, but we would make that available too. I mean, honestly, in this organization that we're in now with WITI, there's a lot of independents and smaller firms that are in need of this. We at CyberBear are here to help them. So the only charge that it wouldn't be an enterprise license at all, and it would be very nominal, where you would probably just have to pay for your own storage, because we include the storage in our license. But we could definitely work with you, Noah, and others that are interested. Absolutely, 100%.
Let's talk. I have your number, I'm pretty sure.
Okay, and you can thank David for that, because he's the one who brought me into the circle of love with everybody. So thank you.
Excellent. Thank you, Pam.
Yeah, I like that.
Just a general question for everybody. Like, I'm not sure how geeky this is or whether I'm kind of talking over people, but is this useful for people? Like, wave if you think that this is useful for you.
Definitely.
Oh,
Are you
I'm glad
kidding
to see
me?
some
Keep
waves.
talking.
Oh, I'm Irish. You
Yeah,
can never shut me up.
right. And I think, yeah, there's no question that's too low. Whatever, you guys ask anything you want to ask. Jerry,
I have a
wait,
question.
Mike, Jerry, and then you. We'll
Okay.
go for it. Yeah, go for it, Jerry.
Yeah, first of all, Raymond, you're an amazing, amazing person. Your knowledge is so deep and you communicate it so clearly, and it feels really good to be able to understand. So thank you so much. I wanted to offer to the group 2 words that I want you to think about a lot. One word is before. The other word is after. Call Raymond before, not after. After decades of being a lawyer, let me just explain to you the number of times there are tears running down my face because, oh, how I wish this person had sought advice ahead of time. Oh, how I wish they had run this by me ahead of time. But afterwards, after those horses are after this guy said that these monkeys did it by accident, oh no. So again, I'll summarize with the words. There's before and there's after. And if you talk to Raymond before, your IQ is really high. If you talk to Raymond after, you'll feel a little foolish possibly. So there you go. Thank you. Thank you, David, for letting me offer that.
Thank you, Jerry,
Thank you
for saying that. What I will say is that actually, after, very often people are a lot wiser after, but it's much more expensive. That doing this, an ounce of prevention is much cheaper than all of the cure that you need to do afterwards. What I would say is an awful lot of people do come to me in the middle of the after. And I've to do this big resistance of not being an I told you so person. I do think internally, oh, it's an awful pity you didn't come to me 9 months ago. But at the same time, a lot of people do come to me in the after, and we do find a way to fix it. But you're right that, oh, it saves so much pain if they would come to me a few months before as well. And it's not expensive to do it before. It's really mad to try and fix it after. So thank you, Jerry.
Right. Thank you, Jerry. Mike, you're up from Maryland.
Hey, hello. I appreciate your time as well. And this is definitely an after conversation.
So that means you're a very smart person.
A lot smarter. A lot smarter. Oh my goodness. I would like to be even more smart, even more smarter, wiser after this question. So I worked at an ad agency, and my IP was stolen. And so my question is, I was told, after doing a bunch of research and talking to attorneys, they told me that it would be a waste of time suing, a waste of money suing. And so I guess my question is, could you, for a moment, express the difference between when you come up with an idea and when it's stolen and when it's not stolen inside of an advertising agency? Like, is it like, someone explained it to me like this, as far as the idea and execution being 2 different things. Can you speak to that at all?
Yeah, even though I say that ideas are valuable, the world is full of people of, I have an idea.
Right.
And a lot of people have the same idea. And it was one of the things that I learned in my MBA is that, an entrepreneur is somebody who didn't just have an idea, that they had an idea, they were alert to a problem, and they did something about it. Very often it meant they mortgaged their house, that they gave up their job, that so they took action on the idea. So that's one thing that sometimes distinguishes people. And you'll find it that nearly anybody who's successful, You'll have 100 people after us. Oh yeah, I had the same idea. And I say, yeah, but did you mortgage your house? Did you go out there and start pitching to people and have everybody laughing at you? You know, that it's great to say I had the idea, but you didn't do the follow-up on that. It's rotten though when you have an idea, somebody steals it, and that they make all the money on it, or they spoil the idea for you. They mightn't even make the money on it, but they spoil it for you that you can't make any money on it either. And that is, you know, it's rotten. And sometimes you just learn from this, and you need to be able to move on from that and just pick yourself up and do better the second time around. Not sure if I answered your question, Michael.
You know, the piece that I didn't divulge is the fact that we all work for the same company, and there was a paper trail, right? It was email. Yeah. Everybody knew that this was my idea, and it was stolen by one of the heads of the company.
Yeah, and that's and again, like there's so many Hollywood people here, and Hollywood is all full of happy endings, but very often those happy endings, like that becomes the movie because that was the thing that so rarely happens. The reality is very often the bad guys do win. That the people who have the lowest morals and that they're prepared to lie the most, they're prepared to steal the most, that they don't care about the consequences, very often they are the people who win, and it's a horrible situation. And you just kind of have to learn from it and just do better the next time around.
Okay. All right. Thank you.
Where there's one idea, there are many, and if you're the creator, there'll be others, I'm sure.
Yes,
absolutely. Mike's got it out already. All right. Thanks.
Dan, you have another question.
Yeah, so I want to go back to the data room a little bit. Most investors, in my experience, aren't really happy to sign an NDA. What about all of the advisors? What about the accountants, the lawyers, the advisory boards, all of that? It just seems to give everybody a free pass. It's not really a great idea. So are there protections you can put in place for what I'm going to say are third parties?
If I can be very crude about it, the biggest protection you have is to not be an idiot yourself. That you need to be careful not to over-reveal. You need to reveal enough for them to be able to make a decision, but not enough for them to be able to steal it all from you. So data room, you don't have to put everything in the data room.
Right.
You have to put in enough for them to satisfy that they're making the right decision. So that is, you know, things that you should be revealing, that you're not hiding things that, you know, material facts that you need to show. But you don't necessarily need to show them everything about how for them to go off and create the same thing.
Right, but then
what I'll also say is, apart from data room, you may already have investors in your company. And it's quite common for people to think that investors have some duty of confidentiality. But very often the investors haven't signed NDAs. They've come on as investors, but they could also be leaching information out of your company as well. So you do need to be careful about that.
Yeah, but my sense
now,
is
if you're talking about legal advisors, though, accountants, that there's also professional obligations on them about information that you give them in the course of what they're doing, that how they handle that information. There are professional obligations on them, which can cause them to be, you know, disbarred or, you know, to have other kinds of problems as well.
Right, but my concern also is, so they see something in a data room, and then they come to you and they go, oh, and we thought about this, and we thought about, it's not in the data room. It's okay to say what we've given you is enough?
What we've given you is enough on this. Now, if you want to go deeper, you haven't signed an NDA for the data room, but if you want to go deeper on these things, then we will need to sign some kind of an NDA.
Okay, thanks.
Thanks, Raymond. All right, Harry, ask your question, then Hooman's going to tell us about our program. Really do it next week and the following. Go for it, Harry.
Okay, great. Raymond, thank you. Great wisdom as always. Just a quick comment and a question. To working with a lot of agencies, often we're signed on as work for hire, which gives them the right to own our stuff versus, you know, going in as freelancers as we often do and trying to own, you know, the intellectual property and the creative. So I don't know if you could speak to that. But I also wanted to say, with working in Hollywood, Noah may know this, any ethical producer, which I know is an oxymoron, the first thing they would do is tell you, don't tell us your idea, right? We got scripts in the back. We probably got a couple similar, unless you go through the proper channels of an agent manager, and submit it that way. So I caution people to be careful about any producer that says, and then, which you've told us many times, Raymond, it's not just ideas are a dime a dozen, even good ones. It's how you execute it, right? And so to do that, and I know Dave,
and you're right that the ethical and the big companies don't want to have the hassle, so they're very careful not to do that. And you're right that sometimes it's the unethical ones, and you'll get a spidey sense of this. This person is asking something they shouldn't be asking, and you're uncomfortable with this. And sometimes you just need to kind of back down, retreat from this, maybe even take a note of when they were asking you what. Like I've had that against one of, I won't say, but it's, if I say, but it's one of the biggest companies in the world. And we won against them because we kept notes of the questions they were asking us that we thought were beyond what they should be asking. And that we saw that this was an intention for them to attack our trade secrets. And we won against David versus Goliath case.
Yeah, and again, it's why you want Raymond up front, right? Go in smart, know what you're up against. And Stone AI's got some great, methods to help protect us from that. And then a quick question, if I could, Raymond. If you have a title, there's, dozens or hundreds of people that might have the same title to a song or a book or a writing, and it's easy to change, right? Because if I have a title and I just put by Harry Caritis, or I change the title, what do I have to do so that I can have the same,
Yes, it's typically copyright doesn't extend to titles. So you will have, different songs, different movies that they may even have the same title. So, because copyright doesn't extend to titles, and it's to do with the more kind of the detail about, the full script or the full screenplay, for example.
Okay, cool. Thank you.
You're welcome.
Okay, Raymond, thank you so much. Amazing as always. We appreciate you so much.
Thank you, everybody, for your engagement. That's really what makes it.
Thank you. Yeah, that was amazing.